Mr. Barr, thank you very much for your willingness to spend time with us today and your willingness to be considered for this important position yet again.
Thank you.
Great to have your family here. And I can't help but comment, a lot of people have talked about Liam today, probably more than any of his other friends or classmates, people of his age cohort. People are thinking about what he might do for a living. Unlike some of my colleagues who have suggested medicine, I want to just sort of suggest what I've suggested to my 3 children, which is that I'm not going to push them into any career choice, which in our family means that you can be any kind of lawyer you want. Just keep that in mind with Liam. I'd like to talk to you first about civil asset forfeiture. As you know, civil forfeiture and criminal forfeiture are 2 very different things, 2 very different species of government taking someone's asset. With criminal forfeiture, of course, the government's ability to take something away is predicated upon a conviction of a crime. With civil asset forfeiture, that happens even in the absence of a conviction. There are some serious questions, of course, regarding the legality and constitutionality of civil asset forfeiture. Justice Thomas, for example, has questioned whether some of these practices are constitutional. I was encouraged to note that in your testimony in 1991, you identified this as an issue. When you testified before this committee, you criticized what you described as the speed trap mentality of forfeiture. Your point was that, quote, agencies should not feel that just because they seize money, they're going to get the money, close quote. Now, since 1991, I've seen our government, our law enforcement agencies actually move more toward this sort of speed trap mentality rather than away from it, as many of us would have preferred. Too often, law enforcement agencies have too strong an incentive to use civil asset forfeiture in a way that lines their own coffers outside of the relevant appropriations process. So let me just ask you the question: Do you think that the speed trap mentality is a problem? And if so, is that something that you'll work to address within the Department of Justice if you're confirmed?
Yes, I think constant vigilance is necessary because there are incentives there that should be of concern in administering the law. And I understand that there are some people who are concerned about it, have some horror stories. The people at the Justice Department have been trying to clamp down. I think Attorney General Sessions put out some guidelines that were supposed to address that. I haven't gotten into it myself. I plan to get into it and see exactly what the horror stories are, where the problems and potential abuses are, and also whether Attorney General Sessions' guidelines are providing sufficient protection. At the same time, I think it is a valuable tool in law enforcement, and the state and local law enforcement officer, our partners, it's very important to them. So I want to make sure we strike the right balance. And once I have a chance to review it, I'd be glad to come up and talk to you about that.
Thank you. I appreciate that. I understand that it's a tool that many consider valuable, but a tool that can be considered valuable for some of those same reasons. Something that's considered valuable to the government can, in many instances, jeopardize an individual right that is protected under the Constitution. We've got to be careful of that. When you refer to the partnership that sometimes takes place between state and federal authorities, this is sometimes where we see it abused. In the case of procedure known as equitable sharing, where sometimes state law might prohibit the use of civil asset forfeiture under certain circumstances. Mm-hmm. And in those circumstances, those state law enforcement agencies might work with federal law enforcement for the specific purpose of evading state law that would otherwise prohibit that. So I hope that's something you'll look into as well.
Yes.
Let's talk about antitrust for a minute. Along with Senator Klobuchar, I chair the antitrust subcommittee. And as I'm sure you're aware, there are a growing number of people who take the position, to embrace the viewpoint that we should use antitrust law to address a whole host of social and economic harms, to, among other things, to ensure that companies respect the First Amendment, or to prevent large companies from becoming too big, or to shape labor markets, or to conform industries to a particular aesthetic, or achieve some other broadly defined social interest. I'd like to know what your view is on this. Are you a believer in the sort of big is bad mentality, or do you gravitate more toward the idea that our antitrust laws are there to protect consumers and should focus on consumer welfare and prices that consumers face?
Yes, I mean, generally, that's where I stand, which is the purpose of the antitrust laws, obviously, is to protect competition, and that competition, it is competition that ultimately redounds to consumer benefits. At the same time, I'm sort of interested in stepping back and reassessing or learning more about how the antitrust division has been functioning and what their priorities are. I don't think big is necessarily bad, but I think a lot of people wonder how such huge behemoths that now exist in Silicon Valley have taken shape under the nose of the antitrust enforcers. And they're, you know, you can win that place in the marketplace without violating the antitrust laws. But I want to find out more about that dynamic.
Right. Yeah, and in some circumstances, a company that becomes too big ends up behaving in a way and exerting market dominance in a way that impairs consumer welfare anti-competitively. In other circumstances, consolidation can bring about lower prices and increased competition. I assume you wouldn't disagree with either of those statements.
No, Senator.
As you know, and as several of my colleagues have mentioned, President Trump signed into law the First Step Act about a month ago. This is legislation that I applaud and legislation that I've been working on in one way or another for 8 years, and was pleased to team up with Senator Grassley, Senator Durbin, Senator Booker, and others to work on that over the course of many years. As you know, the Attorney General has an important role under the First Step Act in appointing members to something called the Independent Review Commission. That Independent Review Commission will make recommendations concerning which offenders might be eligible for earned credits under this legislation and which programs will be approved. When we drafted this legislation, there were some members who were concerned that whoever was the Attorney General at the time of this law's passage and implementation might be able to undermine the effectiveness of this law by appointing members who didn't agree with or believe in the objectives of the bill. So will you commit to me, Mr. Barr, that you will appoint people to that independent review commission who are honest brokers to decide which offenders should be eligible and which programs should be eligible to participate?
Yes, Senator.
Thank you. You familiar with the Ashcroft-Sessions policy, namely the policy requiring prosecutors to charge the most significant, readily provable offense?
Yes, Senator.
Tell me how that should best be balanced out with the discretion of a prosecutor, most frequently, of course, with the discretion of a local U.S. Attorney's office.
Well, I was going to say, I think the best way of balancing it out is to have a supervisor who is able to approve departures from that policy based on the specific circumstances. And there are countless different, permutations of facts that might justify a departure from it. So I think it's best handled by supervisory people. But I also think it has to be looked at centrally. I'm not saying that each case has to be approved centrally, but there has to be some monitoring of what's going on because, as you know, one of the things that led to the sentencing guidelines was, just big differences in the way that the laws were being applied and enforced around the country. And I think we need to try to strive for as much uniformity as we can.
But you intend to continue that policy?
Yes,
And
unless someone tells me a good reason not to.
if I'm understanding you correctly, you're saying that if you do follow it, you will defer to the judgment of the office in question in the case of determining when to not charge the most serious readily provable offense?
No, I won't defer to my I'm not going to say, yeah, I will defer to my subordinates. I mean, usually you do defer to your subordinates, but there might be a case I disagree with, and I'll assert myself on it.
Okay. I see my time has expired. Thank you, sir.